lots of things to tell us. So I think I'm going to hand over to Robin, just to remind all of you that, we will, after today, our Zoom programs will be regularly Monday and Friday. And there is, of course, those of you who are in on it to realize there is a new login code. So we hope that we'll be able to continue to enjoy these Zoom sessions. Thank you, Paul. Thank you, Robin. Right, Henny, you can switch the rest of us off now. Thank you.
Okay, Paul, just unmute.
Yeah, I'm unmuted at the moment.
Yes.
Good morning, everyone who's with us for this talk today. I would like to just say a few words about the process.
Robert, could I just ask people to close their videos as well, please?
Okay. I want to say a few words about the process of the meeting so that we can get the maximum benefit out of the time which Advocate Hoffman is giving us. I will introduce him in a moment, although you can see him at the moment. He will talk for 35 to 40 minutes. There are no visuals to accompany it, so it is require a level of concentration. But during the presentation, you are invited to submit questions and comments on what Paul is saying, and do this via the chat facility that is provided. You can see the chat box on the bottom of your screen. I'm indicating it with my cursor now. And you click on that and another box will drop down, which will enable you to put in a question or a comment. However, it will be confusing if we interrupt the presentation with those questions and comments. So I will be monitoring all the questions and comments that come in, and I will put them on your behalf to Paul at the end of his presentation. I will not mention the name of the person submitting the question, as we are not all known to each other, and therefore it's the content of the question or comment that really counts, rather than the name of the person sending it. So that's the process. Listen to the presentation, send in your comments or questions as we go along, and then I will see that as many of them as possible get to Paul by the time that the hour is up. Now for the introduction. Paul Hoffman, SC, is a native of Johannesburg and a graduate of Wits. I can remember in passing that he was a student at the time that I was a lecturer at Wits, and he recalls me in amusing fashion and one of our meetings earlier. He practiced law at the sidebar from 1975 to 1980, and then at the Cape Bar from 1980 to 2006. He took silk in 1995 and has acted on the Cape bench at the invitation of 3 successive judges president. After retiring from the bar, he was founding director of the Center for Constitutional Rights, and then in 2009, the co-founder of an organization known as Accountability Now. Both of these are NGOs which promote constitutionalism in the country. He's probably best known for the work he did on the irregularities, as he calls them, of the original arms deal, and on the unconstitutional establishment of the Hawks. He's the author of many articles and one book called Confronting the Corrupt, which was published by Tafelberg. So you can see he has a lifetime of experience in dealing with the topic of countering corruption in South Africa. So thank you for being with us, Paul, and over to you.
Thank you, Robin. It's always a test of that 150-word CV that you relied on to see whether the person doing the introduction says judge as president, which is the correct way and which is the way that you did it, or says judge presidents, which is a mistake that is often made. So U3A Hermanus has got the right people in the right places, and it's a pleasure, as usual, to be able to speak to your membership on this thorny but important topic of countering corruption in the year ahead. Today, I'm going to talk around three discrete themes, but I think it's probably important for the membership to know that when Robin was setting up this session, he volunteered to be an unpaid researcher for Accountability Now and did what some would call a desktop dive into the cases of corruption that have been reported in South Africa since 2018, with a view to ascertaining how many people have been arrested, how many have been charged, how many have been brought to trial, and how many have been issued with those legendary orange overalls. So more of that later, but let me immediately say that while Robin modestly says that his research is anecdotal rather than empirical, it is important that this type of activity be monitored and that we are aware of just how well or how badly our criminal justice administration is doing in the task, which is the state's task of countering corruption and ending the culture of impunity, which seems to apply to those in positions of power who have been elected to run the government of the country for us all. The three themes that I'm going to speak around today are, firstly, the paralysis in the criminal justice administration due to the processes of state capture that occurred basically in the Zuma years, although there was some of it before Zuma took charge in 2009. The second theme concerns the lack of political will to effect the reforms that are necessary to bring about changes needed to address the compromised status of the anti-corruption machinery of state, because while we have no anti-corruption machinery of state, we are not going to have any effective way in which to counter corruption. And then the third theme, which will take us through to question time, concentrates on what the law requires of the state to counter corruption and how to get the state to comply with the law. So starting at the very beginning, the paralysis in the criminal justice administration, I think that it's fair to say that the paralysis is partial, but that it is also crippling. It is as if the long arm of the law is the part of the body of the criminal justice administration that has become paralyzed and is unable to do its work in the manner envisaged in the Constitution, which is to prevent and combat all crime. And of course, corruption is a crime. Corruption has been defined in South African context as theft from the poor. And if you think about it, diverting public money away from the public good that it is meant to serve and into the pockets of the patronage networks, the politicians and their fellow travelers who have fed at the trough of corruption, then you do get a very clear idea that theft from the poor is taking place. A good example of that is the decision to divert money that was intended for sub-economic housing in Carltonville into the Nkandla upgrade project, which saw the home of former President Zuma in Nkandla turned into a palace at taxpayers' expense. The paralysis, or the extent of the paralysis, is perhaps best measured by the research that Robin has done to help inform this this talk today. I think that a lot of people in the Hermanus area are very interested to know why nothing has been done about Marcus Jooste, and why Jooste Sagat just continues to pollute the waterfront at Voelklip. The answer to that is that in order to unravel the decades-long scheme that Marcus Jooste was involved in, requires the use of artificial intelligence, that is properly programmed computers, and the bringing to bear of forensic accounting skills, neither of which the National Prosecuting Authority or the Hawks have themselves. So in order to get the prosecution ducks in a row, so as to be able to mount a prosecution of Marcus Jooste for the fraud allegedly perpetrated by him, it will be necessary to have a pretty comprehensive report from a forensic accountant who is able to give credible evidence against Marcus Jooste and his co-conspirators in the looting of the coffers of Steinhoff. And that is something that the state is simply not geared up to do. It is so bad that PricewaterhouseCoopers, who were the auditors of Steinhoff, have been asked to do the preliminary work on that forensic exercise simply because they know their way around and they have the access to the artificial intelligence and the forensic accounting expertise that the National Prosecuting Authority does not have. So while Marcus Jooste has been sent to Coventry by his peers, has been fined by the Johannesburg Stock Exchange in astronomical amounts, and also by the financial control authorities, he still remains under investigation by the Criminal Justice Administration, and nobody should be holding their breath to see him in the dock, let alone in the orange overalls. And he is an example of what is going on. Robin asked the pertinent question, how many people have actually been arrested for corruption, fraud, or corruption-related, what the legislature calls corrupt activities, with a very long and complicated definition of what corrupt activities amount to. And I think, let me just read to you from the note that Robin sent me a day or two ago, in the context of a report that we received about 3 or 4 years ago from the Auditor General, in which he complained that he has sent approximately 3,000 complaints to the National Prosecuting Authority, highlighting cases of fraud, corruption in the supply management chain, and fingering public servants involved in the procurement of goods and services for the state. Those 3,000 cases have not led to any convictions at all, nor to proper investigations. It is almost as though there is an unofficial royal game list of people who do not get investigated by the criminal justice authorities, despite their constitutional mandate to act without fear, favor, or prejudice, and despite the fact that our law requires that we all be regarded as equal before the law and therefore equally susceptible to investigation. Now, Robin's desktop research came up with these numbers. A total of 460 persons have been arrested. The majority are government officials from 58 different sections of the public administration in South Africa. These include 8 national government departments, 7 provincial administrations, 6 local government authorities, and 2 of our state-owned enterprises. High-profile arrests have been made in respect of the police, their Hawks unit, the Unemployment Insurance Fund, the Free State, Gauteng, KwaZulu-Natal, and Mpumalanga provincial administrations, and the Ekurhuleni, eThekwini, and Johannesburg municipalities. The high-profile individuals that Robin was able to identify from his dive into media reports on the topic of corruption include Ace Magashule, who is the Secretary General of the ANC and really the unofficial Prime Minister of South Africa, a former acting police commissioner and deputy police commissioner Bonong Ngwenya, Brigadier Peggy Marongo. Those are both SAPs. The chairman of the VBS Bank, Mr. Maglauzi, former State Security Minister Bongo Bongani, who is still the chairman of the communications, I think it is, the Portfolio Committee in Parliament and refuses to stand down. The former ANC Member of Parliament, Vincent Smith, who got all sorts of favors from Bosasa. And of course, the Bosasa COO, Angelo Grizzi, and his right-hand man, the chief financial officer of Bosasa, that was Mr. Van Tonda. There is also the executive mayor of Durban, that's eThekwini. Her name is Zandile Gumede, and rather than being sent to Coventry for being a person facing charges in a criminal court, she's been promoted to the KZN legislature. So let's ask ourselves the question, that dope you can get from Robin. If you ask him nicely, he will simply forward you what he sent me, and also a table which doesn't lend itself to communication in the way that we are communicating by Zoom at the moment. So let's ask ourselves, how did we get into this state of paralysis? And I think that a major turning point occurred at the Polokwane conference of the ANC in December 2007, at which Jacob Zuma was elected as the president of the ANC. And as a consequence of that election, he became, because the ANC was the most successful political party in the 2009 general elections, he became the president of South Africa and was given 2 terms because he was able to keep politically popular right through to the end of his first term. His popularity dwindled and waned towards the end, and his term of office ended prematurely on St. Valentine's Day in 2018, which is about when Robin started his investigation of news reports of arrests for corruption. At that Polokwane conference in 2009, a very important decision was made by the ANC, calling upon government to urgently disband the Directorate of Special Operations, which you and I know as the Scorpions unit of the National Prosecuting Authority, to transfer the investigative personnel in the Scorpions to the police, and to divide the anti-corruption work of the state into investigations by the police and prosecutions by the National Prosecuting Authority. Now, that legislative scheme was opposed by Bob Glenister and also by the Helen Suzman Foundation. In fact, in the first round of the litigation, a lot of political parties also participated in the assault on the rationality and legality of closing down an efficient and effective anti-corruption unit, the Scorpions, which had a high success rate and which, according to Gwedi Mantashe, who at the time was Secretary General of the ANC, was taking too much interest in important members of the ANC and their friends, and was acting as if the ANC was the enemy. Well, in fact, the Scorpions were acting as if crooks in the ANC was the enemy, and those crooks have managed to enjoy impunity from prosecution with very few exceptions along the way. The legislation relating to the disbandment of the Scorpions and their replacement with the Hawks led to a mass walkout of decent people from the public administration, and in particular from the Scorpions. Shamila Batoy, who is now our National Director of Public Prosecutions, has admitted that she preferred to go and work in The Hague as a special advisor to the International Criminal Court rather than continue in the NPA without any investigative capacity within that independent unit. You will all appreciate that the police are not an independent unit, are not required to be independent in terms of the Constitution, and are under the management and control of a police commissioner who is a political appointee, and under the supervision of the Minister of Police, who is a member of the cabinet and is driving the agenda of the governing party in South Africa. That agenda is called the National Democratic Revolution Agenda, and it involves securing hegemonic control of all the levers of power in society, including the levers of power in the criminal justice administration. So that resolution taken at Polokwane is the basic cause of the current paralysis. A person like Hermione Cronje also left the Scorpions when they were disbanded, did not continue in the National Prosecuting Authority, and elected to go into private practice instead. She has recently been recruited back because of the new dawn that is alleged to have occurred when Ramaphosa took over from Zuma. A person like Anton du Plessis, who has recently been appointed and will take up his appointment in March, went off to work for the ISS, the Institute for Security Studies, and then for the United Nations. And he has decided to return to the fold in the hope of rescuing the rule of law in South Africa. So certainly some people who had the courage to leave the comfort of a secure job in the state administration have been prepared as a consequence of their idealism, or in Shamila Batoy's case, as a consequence of being shamed into doing so by her son. They have been prepared to come back into the criminal justice administration with a view to addressing the partial paralysis which we see, a paralysis which is particularly pronounced in relation to grand corruption and kleptocracy and the features of state capture, which boil down to a massive scheme of corrupt activity where the state is repurposed in order not to serve the interests of the people, but to serve the agenda of those who are involved in the state capture project. So the first point, and I think I'm running past my time now, is that the paralysis has been caused by the decision of the ANC to break up the criminal justice administration into hawks and prosecutors. And of course, if the investigation, which is the hawks' work, isn't a proper investigation, then mounting a proper prosecution is impossible. Now, why is there a lack, the second point, a lack of political will to effect the reforms that are necessary to bring about the changes needed to address the compromised status of our anti-corruption machinery of state? Some of you who keep a close eye on the press will have noted in early August last year that it was reported that the National Executive Committee of the ANC had passed a resolution calling on the government to cabinet to urgently create a standalone, independent anti-corruption body that would be able to deal with the corrupt. And my eyes needed to be rubbed out. I needed to pinch myself to ensure that I was not dreaming that I was reading this in the press report. And things really did look up, because what the resolution boiled down to is a request by the highest decision-making body in the ANC to do what the court told the government to do in 2011 in the Glenister litigation. Unfortunately, because people like Ace Magashula and the entire radical economic transformation faction of the ANC are able to thwart sensible reform of this nature, nothing has been heard since about that resolution and about its implementation. Some say they weren't being serious, they were trying to counter the Futsak ANC hashtag that was trending, that out of desperation, the resolution was passed in order to ameliorate the unpopularity of the ANC. But the truth is that the Ramaphosa anti-corruption agenda is not a fraction of what it should be. The decision to create the investigative directorate, which is headed by Hermione Cronje within the NPA, is probably unconstitutional and is in any event not the answer to the problem, because the unit can be closed down by any president who feels that it is getting too close to his friends in positions of power. So getting to the third point, because I see that the time has now moved on to 10:30, and we do need to know what the answers to the problems are, having sketched them as broadly and as briefly as I can in the time available. What is it that should be done in order to get those orange overalls issued and to stop the paralysis, to address the paralysis in the criminal justice administration that has so sorely damaged the reputation of the country, has undermined peace that is secure, prejudiced progress that is sustainable, and undermined the project of achieving the equitable use of resources of the state to address poverty, want, unemployment in about half of the population of South Africa. In the second Glenister case, in which judgment came out on St. Patrick's Day, 17th of March 2011, the Constitutional Court majority, and it was a narrow majority, and those of you who have been following the Zondo Commission will hear from the evidence of Sidney Mufamadi that some judges were bought by the Zuma administration in order to look after Zuma's interests, and it obviously wasn't in the interests of Zuma for Mr. Glenister to win that case, which he did win against all expectations by a majority of 5 judges to 4. The 5 judges bind the 4 judges, and the 5 judges essentially set out 5 criteria by which to measure the effectiveness and efficiency of the anti-corruption machinery of state. And those 5 criteria, which you've probably heard from me before, so I'll take you through them quickly, are that the unit concerned has to be specialized and dedicated to dealing with corruption and nothing else. Its personnel must receive training that enables them to be smarter at what they do than the corrupt are at what they do. And that requires quite something, because people like Marcus Jooste and Jacob Zuma are very clever. The third of the criteria is independence, by which we mean the ability to operate without fear of the powerful. And when we say the powerful, we don't only mean the politicians, we also mean the powerful gangsters and people with lots of money with which to pay bribes, who don't shirk from paying bribes. The second element of being independent is to act without fear, favor, or prejudice. And the without favor aspect is the ability of the prosecuting authority not to turn a blind eye when there is a temptation to turn a blind eye, because the person who is accused of wrongdoing is highly placed in political circles, a favorite of the governing alliance, or somebody whose position in society would make it difficult to mount a prosecution. And then the third element, without prejudice, means without prejudicing the public interest. So the anti-corruption machinery of state obviously has to be properly resourced, and its personnel must enjoy security of tenure of office. So the STIRS criteria: specialized, trained, independent, resourced, and secure in tenure of office, are what you have when you have a criminal justice administration that is able to protect South Africans against their human rights being undermined by looting and large-scale theft of public resources. And the upshot of that judgment also enables, if the judgment is properly implemented, the state to comply with its international obligations to have effective and efficient anti-corruption machinery of state. That is an obligation which South Africa has undertaken in terms of the United Nations Convention Against Corruption and similar treaties at SADC and African Union levels. So we get ourselves in a situation where we have to get the law and the politics onto the same page, which is why that resolution of the NEC is such an important development, and why the NEC should be held to getting the cabinet to establish anti-corruption machinery of state that is able to avoid the paralysis in the existing institutions by setting up a new institution that is free of saboteurs or backsliders or agents of the Zuma administration, who are there not to look after the public interest, but to make sure that nobody in Zuma's orbit ever goes to jail for corruption. And for ordinary South Africans, it means making a noise about their disapproval of corruption and of encouraging those who are already making a noise, and I think of the Ahmed Kathrada Foundation, the Nelson Mandela Foundation, the Helen Suzman Foundation, and various entities in the faith-based and civil society arena who are protesting against the levels of corruption that are going unaddressed in South Africa. The Archbishop of Cape Town, Thabo Makgoba, and Thuli Madonsela are both in favor of the idea of creating a new Chapter 9 institution that is able to fulfill those STIRS criteria and is able to fulfill the constitutional role of the anti-corruption machinery of state. If the rest of the anti-corruption lobby can be persuaded that this is the way to go, then we are in a position to put pressure on government to do the necessary. Opposition parties are able to put a private member's bill before Parliament in order to embarrass the ANC into voting against a bill which basically embodies what the outcome of the Glenister case was. And in that way, through lobbying and possibly also through litigation that addresses the shortcomings of the Hawks and the Investigative Directorate, we would be able to generate the political will necessary to bring an end to the culture of corruption with impunity and to effectively counter the incidence of grand corruption in South Africa, corruption which is really eating the heart and soul out of the multi-party democratic project where the rule of law is meant to be regarded as supreme and not as an irritation that gets in the way of those who get into positions of political and economic power for the purpose of enriching themselves rather than for the purpose of serving the interests of the people. I see now that I've taken up a good 35 minutes, so let me stop there. I think the timing worked more or less, and let's go and look and see what's in the chat room.
Thank you very much, Paul. There are a number of questions that have come through, and I'll put them to you in my own words because the typing is not always what it should be. The first question is, could you please explain the nature of a Chapter 9 institution and why the anti-corruption unit should be established under that particular part of the Constitution?
Yes, do you want me to take that one straight away?
Yes, I think we'll do them one at a time, yes.
Yeah, okay. In traditional constitutions, there are three branches of government: the legislature, which makes the laws, the executive, which administers the laws, and the judiciary, which sits in judgment of disputes, either between state and individual or between individuals. In the South African Constitution, a new and fourth branch of government has been created. That is our Chapter 9. And there is a lovely summary of what Chapter 9 is about on the homepage of the Accountability Now website. A little handbook, which you can download for free, called Know Your Rights, Claim Your Rights, is there, and it has a chapter of the book about Chapter 9 institutions. So the Chapter 9 institutions that we all know are the Independent Electoral Commission, the South African Human Rights Commission, the Gender Commission, the Public Protector, and the Auditor General. And what we are looking to do with an Integrity Commission, which is the new Chapter 9 institution that is needed is to slot it in between the Auditor General, who is like a canary in the coal mine and picks up financial irregularities at an early stage, and the Public Protector, whose mandate is mainly about maladministration and not about corruption as such, although there was quite a lot of scope creep during Tuli Madonsela's time because there was no effective anti-corruption machinery of state while she was Public Protector. So why a Chapter 9 institution is a good question, and the answer is that it was possible to close down the Scorpions, who were good at what they were doing. We have the talent, we have the experience, we have the expertise to counter corruption in South Africa. But what we didn't have was an adequately protected anti-corruption body. So the Scorpions were created by an ordinary law, an ordinary statute passed by a simple majority in Parliament, and they were closed down in exactly the same way. So any party that can muster a 50% plus one, that is 201 votes in the National Assembly, is able to close down an anti-corruption unit that is not to its liking for reasons that were apparent in relation to the Scorpions' unhappy relationship with those in the ANC who chose to paint outside the lines. The only one of the STIRS criteria that the Scorpions did not have was the security of tenure of office. And the way in which to secure tenure of office is to give the new anti-corruption body the protection afforded by Chapter 9 of the Constitution, which says that you cannot close down a Chapter 9 institution unless you can command a 2/3 majority in Parliament, which is something that no political party in the current setup is able to do. And if we are to believe the research into voter preferences at the moment, the majority of the ANC will either be reduced or eliminated when next we have a general election at national level. We will certainly learn a lot in the course of this year about trends in politics in South Africa. And I think that it is possible that the liberation dividend, which the ANC has enjoyed for more than 2 decades, is actually running out of tarmac, and that many people either not vote or vote against the ANC in order to mark their displeasure with the way in which it is governing. Certainly, in the current political alignment, a Chapter 9 Integrity Commission, once established with the support of the majority in Parliament, will not be able to be closed down easily because a 2/3 majority is required. So the reason for Chapter 9 is because it is not easy to close it down, and it would not be, had the Scorpions been a Chapter 9 institution, we would still have them today. Jacob Zuma would have gone to jail instead of to the Union buildings, and many more prosecutions for corruption would have been successfully concluded by now.
Thanks, that's very, very helpful to know that. The next question comes from two sources, but I've put them together, and it involves some degree of personal knowledge that you might have, Paul, or intelligent speculation. What it boils down to is the question of why has the campaign to undermine the integrity of public officials and to involve them in corruption been so successful? Is there someone planning this? Is the deployment of cadres specifically worked out in order to place corruptible or already corrupt people in important offices? And is there some kind of mastermind behind this whole thing that explains why it has had the devastating effect that it has had? Or is it just lots of individuals pursuing their own selfish interests that have caused the collapse that we see?
Yes, that's a very interesting and difficult question to answer without getting into the realms of speculation. But if you're looking for well-informed speculation, have regard to these facts, which is that, first of all, the strategy and tactics of the governing alliance, which consists of the ANC, the South African Communist Party, and remember, it's a communist party with a Stalinist agenda, and the COSATU Federation of Unionists. And remember, these are not sweetheart unionists. They are unionists with at least a socialist bent, if not a communist bent. Their strategy and tactics, as spelt out on the website of the ANC, are to propel the national democratic revolution to the point where it is possible for the revolutionaries to attain hegemonic control of all the levers of power in society, not in government, in society. So things like expropriation of private land, banks that belong to the state and not to the private sector, the idea of I hope I'm still there because I'm...
Henny, are you on us?
Yeah, well, I can hear you, so I hope you can hear me.
Yes.
Just lost my pretty face, which is not a great loss, so I'll soldier on. The National Democratic Revolution is not aimed at the implementation of the Constitution of South Africa. The features of the National Democratic Revolution, its essential features, are actually inconsistent with the Constitution. And in order to get that revolution to take place, it is going to be necessary to undermine the established order in South Africa, and indeed to undermine the tenets of constitutionalism. If you look in Politics Web in May last year, you will see that I remarked there on a media conference that was held by Nkosazana Dlamini Zuma, who may have been, had Cyril Ramaphosa not moved so adroitly at Nasrec, she may have been our president today. She said, the pandemic presents the opportunity to bring about the radical economic transformation that has long been in the planning in the corridors of the tripartite alliance. She even talked about class suicide, which is a theoretical position where those with their hands on the lever of power sort of commit mass suicide by handing over power to the proletariat. It's something that's never happened anywhere in the world, and it's certainly not going to happen in South Africa, but it is indicative of her mindset. She does not like capitalism, she does not like smokers, and she does not like drinkers. So she has plenty of enemies, and her answer to the pandemic is to use it as the opportunity for advancing this comprehensive control of all the levers of power in society agenda, which is not what the Constitution is actually about. And certainly, cadre deployment is part of the problem. If you deploy a cadre as a consequence of the activities of a cadre deployment committee in Luthuli House, you are immediately putting that person in a conflict of interest situation. His loyalty, her loyalty, is to the cadre deployment committee, not to the people of South Africa. So if you are a municipal manager in Pofadder and the pump at the sewerage plant breaks down at the same time as the mayor's son drives the mayoral car into a tree on a Saturday night, you will spend the money of the municipality on replacing the written-off motor car long before you spend it on replacing the broken pump. And that has happened on a massive scale throughout the country, as a consequence of which municipalities are limping along in a dysfunctional state because the deployed cadres do not act in the public interest and do not implement their constitutional mandates. They look after the cadres who deployed them. So I think that answers both legs of why it is that we're in such a mess.
Thanks, Paul. There's a subsidiary question about the role of Black economic advancement of the privileged. What role has that played in the present malaise that we are talking about?
Yes, I'm afraid this is the glorification of victimhood and its abuse by those who have never really been disadvantaged to put themselves into cushy positions of economic power. The prime example of which is Cyril Ramaphosa himself. He left politics in a fit of pique when he did not become the successor to Nelson Mandela, and he went into business. But the billions that he has amassed through his business activities are all attributable to Black economic empowerment policies rather than to any effort on his part, any enterprise or entrepreneurialism that he has brought to bear. And many people in his position have exactly the same story to tell. The Black economic empowerment provisions are inconsistent with the equality clause in the Bill of Rights. We are meant to be living in a non-racial, non-sexist environment, and we are meant to be equal before the law, and we are meant to put in place laws and measures that advance the disadvantaged. Now, the disadvantaged are no better off than they were in the days of apartheid, whereas the politically connected people who dress themselves up as disadvantaged by wearing a black skin are in a much better position than they were in during the days of apartheid. And the abuse of the Constitution through the race-based affirmative action measures of BEE is really one of the bigger crimes of the ANC during the past 25 years.
Yeah, and Robert,
That's a very good answer to that question. And it also answers another question which came up. Is Cyril not hamstrung by his own involvement in previous shenanigans? But I take it that you've already answered that question by your reference to his own involvement in that. Another question that came up, might give a couple of minutes on that because we're coming towards the end of our hour. Is the Zondo Commission likely to result in any serious action against corruption?
Look, what you need to remember about the Zondo Commission is that it is not a court case. There are no accused people before a judge. The Zondo Commission is a fact-finding inquiry which has been asked to find out what happened around the concept of state capture and to make recommendations to the president about what should be done as a consequence of the findings that are made. Now, the findings of fact are not binding on anybody, do not lead to a conviction or to a successful claim for damages or to the raking back of loot that has been stolen from the people of South Africa. The findings are there on a take it or leave it basis, and anybody who wishes to challenge a finding concerning him or her is at liberty to do so. If the Criminal Justice Administration wishes to swing into action on the basis of what has emerged at the Zondo Commission, then it must be in a position to produce evidence itself in relation to the elements of the crime which it alleges in the charge sheet applicable to the individual who is charged. As far as the recommendations of the Zondo Commission are concerned, one can look forward with a bated breath to a recommendation that BEE should be scrapped, that cadre deployment should be declared illegal, that a Chapter 9 institution should be brought into existence to deal with corruption in accordance with the Glenister case as a matter of urgency. All of those are feasible recommendations of the Zondo Commission, and none of them bind the government to accept the recommendations made. They are made on a take it or leave it basis, and very often a commission of inquiry of this kind is used throughout the world by a government to park a political hot potato until it cools off, and then to move it somewhere to the back of the stove where everybody forgets about it until it falls off the back of the stove and disappears into that dark space behind the stove where the mice and the cockroaches live.
Thanks very much for that, Paul. I see our hour is coming to an end. Perhaps I can just draw attention of the members who are attending to a survey that was published yesterday by the internationally renowned Ipsos Foundation, which surveyed 27 countries on a very systematic basis as to what they were, which were the countries that were, the population was most worried, and what were they worried about. Of the 27, South Africa was the most worried country. 78% of the respondents indicated that they were worried about what the government was doing, which may have a bearing on your speculations about the elections. But interestingly enough, 26 of the countries listed the pandemic as the thing they were most worried about. The pandemic only came third in South Africa, behind corruption and unemployment. So if that is actually an accurate indication of public opinion, then there may be some progress that we can make in combating corruption. Paul, thank you very much for a highly informative and brilliantly executed summary of the situation, and for the time and effort that you must have put into this. On behalf of the U3A, thank you very much. And may I say to the other members who are with us, thank you for attending, and to remind you that there is a presentation on this channel on Friday on a very different topic. I will be speaking on the history of the Ferncliff Nature Reserve, and I hope that you will find time to attend that. This presentation has also been recorded and in due course will be available to any of you who have watched it, or for you to recommend to your friends who did not watch it, that they should look for it from the U3A and watch it. So thank you all for attending, and good day.
Thank you, Robin. Thank you, Paul. Thank you, everybody. See you on Friday.
Thank you.
Thank you.